Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
Know your lane for what you saying, yo. Silly with my 9 milli with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While up in the club, like we while in the studio. You don't wanna vibe, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. Like a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, look at shorty, she a little cutie, yo. The way you shake it, make me wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. Fuck me, see what you got for me. Put more than dance with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than dance with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. Fuck me, see what you got for me. Put more than dance with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than dance with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than dance with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than dance with my eyes to see. Still $1 in the place to be. If you.
Here comes the pitch, and it comes in wide. On the count ball.
Give me a second, guys. I'll be right with you. Hello. Good evening, everybody. How's my OCOV family in the building? How are we doing today, everybody? So let's say hello. What's up to everybody in the building, those in the bushes, those that love me, those that hate me. What's up? What's happening? Hey, Noonie. What's up, mama? Fat boy. What's up, my fat boy? Hey, I am Queen. LaKendra, what's up, mommy, with them shits and giggles, girl? Shorty rara, what's up? My SK is in the building. Pita, what's up, my Pita? Hey, Dorothy, what's up happening? What's happening? What's up, Dorothy? Indigo, what's up, my love? Rocking with the truth. What's up, baby? My Ty. Kelsey's. What's up, my beauty baby girl? All right, mama. Yes, please don't forget to hit the like button on your way in here, guys. It takes 2 seconds. Don't cost you a thing. You won't break a finger just tapping it. Okay? Okay. Lovely's fair. What's up, papito? I love the fact that I really know what you are now. I feel better now. So, guys, I am anxious. I've been anxious all damn day. I'm not even going to lie. I had knots in my stomach. I've been on a fucking Gmail watch all day. It's crazy. I've been on a Gmail watch all day long. All day long. You don't see Dorothy, mama? She must have you blocked. Or you have her blocked. I mean, yeah, you might have her blocked. You did it, Noonie! Noonie! R. Kelly's a dog. Hey, what's up, my beautiful lady? Hi, baby. Noonie! Guys, don't forget to become a member. I have an exclusive. If you want to know, you got to be a member. I love you, Noonie Bendito. You finally figured it out, mommy. God bless you. Dorothy, unblock Ty. If you have Ty blocked for some reason, I don't know, maybe. Or Ty, you might have her blocked. I don't know what's going on with that situation. Maybe you need to refresh your screen, Ty. Sometimes that happens too, baby. You know, put live chat instead of top chat. Sometimes that works too. Yes, hello to everybody. Guys, get it all out. Say hello. No, mama. What, you don't have her blocked, baby? Can you see Ty? Do you see Tyro with Okov in there? That's right, Noonie. You here. That's what matters. You already know. We love you, baby girl. Please, girl. That's what matters. You're here, mama. You know, pero bendito, she was having a hard time. She really wanted to be a member, and we was trying to figure it out for her. Shit, it was ridiculous. We was going crazy. Jesus, the baby was bouncing in her belly. She was like, forget it. I'm giving up. I'll figure it out another day. There you go, mama. You could use them stickers. You see them little stickers? Okay, bueno. I got the sticker there that says bueno. ¿Qué tú dijiste que it just dropped? What dropped, babe? Oh, it just dropped. Let me see, guys. Hold on. If it did, we are going to go and read it. Hold up. Hold up. Oh. Okay, here we go. Let me see what I got here. Oh, okay, wait. All right, I gotta go back. Hold on, guys. Give me a second. I'm going through my phone, y'all. Let's see what's hood right now. Okay, hold on. Let me see what's hood. Okay, let me see. I think that might be something else. Let me see. Let me refresh this real quick. Let me see. Oh, yes. Oh, yes. Yes. Okay, guys. All right, guys. Here we go. All right, government just dropped it. Fuepa. Okay. All right, this has two parts. No, cancel that for the moment. Okay, wait. Hold up, guys. Hold up. All right, y'all. Okay, so this is 1, and this is 2. Defendant Robert Kelly's notice of supplemental motion for a new trial. And this one is Defendant Robert Kelly's memorandum of law in support of his supplemental for new trial. Wait. Okay. So Bonjean just put in the motion for the new trial, guys. The government hasn't responded yet. Wait, what? Hold up. Yes, Bonjean put in this motion, guys. Yes. This is a motion put in by Bonjean, y'all. This isn't the government's response, guys. I'll change the title later. I'll change the title to the video later. Let's get into this. Okay. Let me prepare the screen. Let me prepare everything, guys. Give me a moment. Okay. Let's see if this is good enough or it's too wide. Okay, now this is good. Okay, y'all. Put my highlighter on. Okay. Well, Miss Bonjean jumped in at the chance. She sure did. Dale dice, espérate, hold on, wait a minute. Since y'all being all slow, let me be really fast. She got some tricks up her sleeve, huh? Mm-hmm. All right, guys. Let me know if you guys can see the screen. Let me see. I think I want to change the view. We're going to change the view. Okay. All right, now. I gotta go. Where am I at? Oh, no, I'm at this window over here. I forgot I'm at a specific window. Okay. All right, guys. Here we go. Well, this was put in moments ago. Defendant Robert Kelly, notice of supplemental motion for a new trial. Please take notice that upon the accompanying memorandum of law, Defendant Kelly, through counsel, hereby moves for a new trial on supplemental grounds. Respectfully submitted, Bonjean. Go, Bojo, go. Okay, certificate of service, blah, blah. Okay, that was it. All right. That was that page. Let's blow this sucker up. Okay. Move this out. Close this. Okay. No. All righty. Now, Defendant Robert Kelly's Memorandum of Law in support of his supplemental motion for a new trial. Oh my God, my son is OD over there. He got to get off. All right, now, introduction. Defendant's trial was engulfed by, hold on one moment, guys. Oh my God. I am so sorry. I deeply apologize. Oh my God. Lord, thank you, fat boy. Oh my God. Let me start over because Miss Bojo over here got me spinning. Okay. Espérate un momentito, replay. Let's rewind. Hold up, guys. Okay. The introduction. Ms. Bojo says the defendant's trial was engulfed by irrelevant and excessive bad character evidence that added little to the jury's assessment of whether defendant committed the charged offenses. Indeed, the 6-week trial was comprised overwhelmingly of uncharged bad act evidence that served no legitimate evidentiary purpose. With the court's blessing, and I can't even believe she used that word, Lord, hold the wheel. Okay. The government subjected the jury to a mass repugnant conduct for the primary purpose of depicting defendant as contemptible sexual deviant. Now, guys, what is the word contemptible? Meaning in contempt? Is that what that means? What is contempt? All right, I'm gonna have to look it up, guys. Give me a second. I gotta look up this word. What is contemptible? I'm thinking it might be in contempt, right? In contempt of these bad acts, right? Let me go look this up real quick. All right, a bowl. Right, let me look at it again. It is CONT, contemptable, right? Okay. Contemptable. Okay, I did it. Bing, boom. Okay. Okay. And they spelled the word wrong. It's actually contemptible. IBL. CONTEMPTIBLE, which means deserving contempt, despicable, heinous, shocking, offensive, shameful, cowardly, low, unworthy, detestable, hateful, reprehensible, deplorable, loathsome, revolting, unspeakable acts. Okay, Bo-Jean. Okay, Bobo. Okay, Bobo. Bobo said the primary purpose of depicting defendant as a contemptible sexual deviant. Well, you goddamn right. I think he is. What about all you guys? I think he's contemptible. Yes, I agree. He's a whole sexual deviant who's done heinous acts with minors. Okay? Yes. Okay. Then it says the government defended the introduction of the evidence as relevant to the means and methods of the enterprise. Yes, and I absolutely think they were. I do. What about you guys? Do you guys think so? I think so. I think those bad acts were relevant to the means and methods of the enterprise because it showed the enterprise, the octopus, the people that work inside who get paid, right? They had these means and methods, and their means and methods were to grab girls, drive them around, drop them off, pay for hotels, give them phone numbers, Those are means and methods of an enterprise. They help R. Kelly build RSKLLC. Without these people, R. Kelly would just be an individual by himself, still being charged with racketeering. How about that? Because he's an individual who is the sole proprietor of his business. I'm just saying, the law is the law. So it says that the government defended the introduction of the evidence as relevant to the means and methods of the enterprise, with nary a word of Rule 403 considerations. With nary a word? What is nary? What is this? I've never heard of this word. What is this word? What is nary? What? She's throwing these words at me. Hold up. Slow down, Bojo. Girl. ¿Qué tú estás haciendo? What are you doing? Let's look up this word. Hold on 1 second. I ain't never heard of this word before in my life. Hold up. What's the word again? Double check it. Nary, right? Yes, nary. Nary. Okay. Let's look it up. Nary. Actually, it's pronounced that way. Nary. Okay. Nary means non-standard form of not. Nary a murmur or complaint. Non-standard form. Okay. All right, girl, you could have just said not. Without standard form. Okay, so in other words, she's saying that the government defended the introduction. So the judge and the government, the government, the prosecutors defended the introduction, and the government ruled on the judge ruled on it to introduce the evidence as relevant to the means and methods of the enterprise. And she's saying, but with no form of a word, not the form. Wait, what is it? In a non-standard form. She's saying that in a non-standard form, a word of Rule 403 was considered. So with the non-standard form of the word of Rule 403, she's saying that she didn't consider the Rule 403. She said, for reasons argued in Defendants Rule 29 motion, the government's evidence of an enterprise was insufficient as a matter of law. This case was not about an enterprise. It was about the conduct of one man who the government sought to punish for his alleged history of mistreating women. Girl, you better sit. Bojo. ¿Qué tú estás diciendo, Bojo? What are you talking about, girl? Girl, did you look at those transcripts? I don't think she went through all those transcripts. I don't think she did. That's bullshit. She ain't go through them transcripts. Her clerk did. Wait a minute. ¿Qué di qué? they didn't prove as a matter of law that the case wasn't about an enterprise. First of all, the case was about an enterprise, and it was also about his mistreating women, girls, minors, little girls, not women. Take that shit out of there. Alleged history of mistreating girls, little girls, minors, teenagers. That's what she was supposed to put there. She's trying to confuse people. Girl, sit down. As such, the mountain of bad act evidence offered in this prosecution was nothing more than inadmissible propensity evidence. Wait a minute. Oh. It's a mountain, guys. Mountain of bad acts. You damn right. And he's lucky he didn't get charged with all those bad acts. How about that? Can we go for a new trial and maybe charge him with all those bad acts so he could just be charged with everything? Can we do a Larry Nassar on him? Can we do a Larry Nassar on him and have all of them charged? All of them. Every single last person as a Jane Doe and a John Doe should be charging R. Kelly's ass. He should be so lucky that they did it. He should be so lucky that they're just using those Jane Does and John Does as examples of his pattern of behaviors. Now, all those John Does and Jane Does were used to show his patterns as corroborating evidence. Bad acts are sufficient admissible evidence. It says it in the law. It's in there. Let's look up Rule 403 real quick. Let me go. Hold up. Okay. Rule 403 has to do with excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. So it says that the court may exclude relevant evidence if it is probative, value is substantially outweighed by a danger of one or more of the following. So the court can exclude this relevant evidence if it is probative value, if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. So, notes of advisory committee on proposed rules. The case law recognizes that certain circumstances call for the exclusion of evidence, which is of unquestioned relevance. So these circumstances entail risk, which range all the way from inducing decision on a purely emotional basis at one extreme to nothing more harmful than merely wasting time. So at the other extreme, situations in this area call for balancing the probative value of and need for the evidence against the harm likely to result from its admission. Okay, and then it cites the law, and then it says the rules which follow in this article are concrete applications involved for particular situations. However, they reflect the policies underlying the present rule, which is designed as a guide for the handling of situations for which no specific rules have been formulated. So, exclusion for risk of unfair prejudice, confusion of issues, misleading the jury, or wasting of time all finds ample support in the authorities' unfair prejudice, quote unquote. Unfair prejudice. So within its context means an undue tendency to suggest decision on an improper basis, commonly through not necessarily. Commonly, though not necessarily, an emotional one. So the rule does not enumerate surprise as a ground for exclusion. In this respect, following Wingmore's view of the common law, listing unfair surprise as a ground for exclusion. So it was, now, first of all, Miss Bobo, it was not a surprise. They knew about it when they got the discovery paperwork, when they got the 3,500 paperwork. They got the paperwork of all the bad acts and uncharged acts. They knew who was going to be in there. And it wasn't last minute. It was only last minute because Greenberg was being slow. I don't know. I'm just saying, right? Supposedly, he didn't show his other teammates the paperwork. I don't know. That's what they were saying in the streets. I don't know. I'm just saying, allegedly, right? So, Bojo, I don't know what you're talking about, girl. I'm confused here. I'm confused. So, it wasn't a surprise, mamita. It wasn't a surprise because they knew about it. It actually it was talked about in the motion to bring them in. And when they came back, they only wanted to take out a couple of the Jane Does. They didn't want to dismiss all of them. They only wanted to dismiss some of them. Some of them were the only ones they didn't want to come in. There was quite a few of them that they didn't want to come in. I forgot what it was. We could go over that too. It was a lot of them. I mean, they were like blah, 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 blah. But the judge said no. She said, no, this is perfectly lawful. These people are bad acts and they are examples of his actions. So, yes, we are going to submit them all. Every last one. She didn't dismiss anybody. They only used certain ones on the stand. So, let's see. Then it says, all find ample support. Okay. Okay, ground for exclusion by stating that it is usually... Okay. So listing unfair surprise as a ground for exclusion, but stating that it is usually, quote unquote, coupled with the danger of prejudice and confusion of issues, unquote, quote unquote. While Uniform Rule 45 incorporates surprise as a ground and is followed in Kansas Code, okay, that's something else, in the Kansas Code procedures, says surprise is not included in California Evidence Code or New Jersey Rule 4, though both the latter otherwise substantially embody Uniform 45. While it can scarcely be doubted that claims of unfair surprise may still be justified despite procedural requirements of notice and instrumentalities of discovery, the granting of a continuance is a more appropriate remedy than exclusion of the evidence. Tentative recommendation and study relating to the Uniform Rule of Evidence. Moreover, the impact of a rule excluding evidence on the ground of surprise would be difficult to estimate. In reaching a decision whether to exclude on grounds of unfair prejudice, consideration should be given to the probable effectiveness or lack of effectiveness of a limiting instruction. See Rule 106. Okay, that's different. Something else. So the language of Rule 403 has been amended. Okay, so the Rule 23 was amended, 403 was amended in 2011. So the language of the 403 has been amended as part of the wrestling of the evidence rules to make them more easily understood and to make style and terminology consistent throughout the rules. These changes are intended to be stylistic only. There is no intent to change any result in any ruling on evidence admissibility. So those are the committee notes on Rule 2011 was amended. So there is no intent to change any results in any ruling on evidence admissibility. So they think that it's a waste of time. They shouldn't have done it due to the fact of the wasting of the time and so forth, so forth. Okay. So, as such, the mountain of bad act evidence offered in this prosecution was nothing more than inadmissible propensity evidence. Because defendant was forced to defend against dozens of uncharged claims of abusive and sexual misbehavior, much of it lawful, albeit unpalatable for some. Much of it was lawful, albeit unpalatable for some. Girl, you got to stop using all these. I was just a Greenberg. Greenberg kept it straight to the point. What happened? Sorry, guys. I got munchies, so I just went to go get me a little yogurt. Okay. All right. Let me see what y'all saying in the chat. At Diva, it doesn't mean non-standard. Nary is just a non-standard word for not in English instead of not. When I looked it up, it said non-standard form. That's all. Non-standard form. Right? Okay. So a non-standard word for not in English instead of not. Okay. So it's not kind of like I figured, kind of like the word not, right? Okay. Right. See, exactly. Means not. Okay. Yeah. See? Okay. See, thank you, Sarah, for clearing that up. That's what I thought it meant. Not. Right. Okay. So I was right. Thank you. I was right in the non-standard form. They were using that word, but it means not. Okay. Got you. Not. Not. Oh, okay. You speak Old English. Right. Right. I get it, babe. I get it. So, the defendant was stripped of the presumption of innocence and denied a fair trial. How was he denied the presumption of innocence? Because they added those bad acts? Really, Bojo? Interesting. Interesting fight there. Mm-hmm. But that is not all. Defendant was denied effective assistance of counsel when his attorneys failed to file adequate pre-trial objections to the introduction of the mass of overlay prejudicial propensity evidence and routinely failed to lodge timely objections to some, although not all, of the damning bad act evidence. See, I told you. I was right. Right. They didn't ineffective counsel because they weren't speedy, they were late. They were late putting in some motions, so they were denied. That's like I went back and I looked back at the paperwork now, and I was like, damn, they did a lot of stuff for bond. They didn't do too much of they did a motion to strike, to dismiss evidence. They didn't do too much. It was all about trying to get him out of jail, really. Basically. So well, at least she admitted that, you know, they were damning bad acts. At least she can admit that they were damning. You know, like, damn. At least she can admit that it's damning. In sum, defendant's trial was little more than a reenactment of the one-sided docuseries Surviving R. Kelly, which several of the jurors had viewed before stepping into the courtroom. It is a wonder that the government did not simply offer the docuseries into evidence. Oh, God. She said, with this backdrop, She said it is a wonder that the government did not simply offer the docuseries into evidence. She said with this backdrop, defendant was powerless to defend against the charged offenses. What? That just means he had no type of evidence of his own to rebut all those bad acts. He had no evidence. Nothing. It's just his word against theirs. That's it. That's all. That's it. That's all. He didn't have any paperwork that said, I don't have herpes. Nothing. He didn't have anything to prove that he didn't have sex with none of those girls. Nothing. He couldn't even take the stand. How about that? Huh? He could have decided to stand up against his accusers and face them, right? He could have said, you know what? Fuck this shit. I'm going on the stand. I want to go on the stand because I am innocent. And the people need to hear me. Ask me the questions. I'll tell them no lies. He didn't do that. He couldn't even tell his lawyers the truth. He hid from his lawyers the fact that he had another storage unit. He hid the fact that he was married to Aaliyah from the people for pretrial services. When they questioned him, he failed to mention it. But then Greenberg and Leonard admitted it. Greenberg admitted it in an interview on an interview with a reporter. Leonard, I think it was Leonard or Farinella, I don't remember which one it was, said it in the trial. Like, yeah, okay, yeah, well, okay, well, I'm going to shut up now and sit down. Okay. Yes, it did happen, Your Honor. Okay, well, whatever. Okay, let me. Really? This motion is interesting. Mm-hmm. So, defendant was powerless to defend against the charged offenses for which there were viable, even winning defenses. Wait a minute. Really? She thinks that there was viable winning defenses? Really? I can't wait to see her in action. This is going to be interesting. I don't think you're going to win this one, Bojo. I'm sorry. Blue Lagoon. Tom Bella. What's up, guys? Who else is in the building? Hey, Aisha. Hey, June prays without ceasing. Hello, welcome, welcome, welcome. Okay. Okay. Denied, right, Tears. Denied. So now, she's like, defendant was denied his constitutional guarantee of a fair trial where the jury heard excessive, minimally probative evidence of contemptible, see, they spelled it right here, conduct that was introduced solely to inflame the passions of the jury and punish the defendant for decades of unchecked bad behavior. Well, Bojo, again, I'm going to say it. He's lucky he ain't get checked. How about that? You want him to be checked? I think if they go for neutral, why not? Superseded, make it a whole nother fucking, let's add them all. Add them all. Add them all. That's what should happen. Yup. Add them all. Next, we're going to go into relevant facts. In the 2 months preceding the start of defendant's trial, his defense team was focused on fighting one another and preoccupied with litigating a cursio hearing on account of one of his attorneys disabling conflict of interest. Not surprisingly, defendant's trial team wasted valuable time and resources focused on this side circus rather than preparing a strategy for defending the case. At the defendant's request, this court granted an extension for the filing of motions in limine until July of 2021. Docket number 131 on July 23 of 2021. The government filed a whopping 55-page motion seeking to admit a heap of prior bad act evidence. Docket number 133. Defense counsel filed no motions in limine. Incredibly, defense counsel failed to preclude any uncharged bad act evidence that was produced as part of the government's 3500 material on July 30th of 2021. Defense counsel filed a written objection to the government's motion in limine regarding the introduction of prior bad act evidence, largely on timelessness grounds. Docket number 145. The response contained a general objection to the evidence as untimely with no meaningful relevancy objections or Rule 403 analysis. Right, that they were late. That's what I'm saying. They were late with that shit. Oh well. Okay, inexplicably, defense counsel did not seek a continuance of the trial to investigate these alleged surprise witnesses, but merely asked the court to strike them. Yes, that's what they did. They asked the court to strike them. Right. At a final pretrial hearing. Right. That was when they added the ones they added. I think they added all of them. I don't even remember. Or they added just certain ones. I forgot. At a final pretrial hearing, defense counsel conceded that he did, in fact, know who the other bad act witnesses were and was familiar with their allegations. Defense counsel conceded that he was in possession of all 3,500 material and had received supplemental 3,500 materials from the government. Now, on August 6th of 2021, defense counsel filed a 2-page supplement opposition to the government's motion to admit other bad act evidence. That was when they wanted to add Joe. Throughout trial, defense counsel filed a handful of letters objecting to the introduction of certain bad act evidence. Those objections were largely overruled. So the record does not seem to reflect objections to much of the uncharged bad act evidence offered by the government. Oh boy. Argument. Defendant was denied a fair trial when his jury was swamped with a mass of minimally probative, cumulative, and unduly prejudicial other bad act evidence, some of which was admitted without objection in violation of Defendant's Sixth Amendment guarantee of effective assistance of counsel. So she says, with virtually no limitation, this court permitted the prosecution to inundate the jury with excessive bad act evidence, mostly under the theory that the evidence was relevant to the means and methods of the enterprise. The means and methods, justification for the introduction of copious amounts of bad acts evidence is gravely flawed because the government's theory of an enterprise is flawed. Where the enterprise consisted of nothing more than the purported sexual misbehavior of the defendant, unconnected to the activities of a discrete enterprise. The means and methods. Excuse me, guys. Let me get some drink. Hold on. All right. The means and methods, justification for the introduction of copious amounts of bad act evidence is gravely flawed because the government's theory of an enterprise is flawed. Where the enterprise consisted of nothing more than the purported sexual misbehavior of the defendant, unconnected to the activities of a discrete enterprise. The means and methods, relevancy, justification is meaningless. As argued at length in the defendant's Rule 29 motion, the government failed to prove that defendant was distinct from the so-called enterprise, no matter how much repellent evidence of sexual indiscretions or abusive behavior the government accumulated against the defendant. The facts remain that it was the defendant and the defendant alone who engaged in those affairs, wholly disconnected to the affairs of a distinct enterprise. Wait a minute. Hold up. Yes, his behavior of abuse was solely him. But everybody else around him was working for him on behalf of him. So whenever he wanted a girl, he had his people go get them, bring them to the hotels, bring them to the concerts, bring them to the venues, bring them shopping, all these other things, bring them food, watch them if they're locked on a bus, watch them while they're going shopping, make sure that they don't talk to them, right? You know, these things happened here, right? So sexual indiscretions or abusive behavior the government accumulated against the defendant. The facts remain that it was the defendant and the defendant alone who engaged in those affairs, wholly disconnected to the affairs of a distinct enterprise. By characterizing defendant's purported decades-long history of abusive conduct towards women as an enterprise, the government not only avoided statutes of limitations, but was free to introduce any unkind or abusive act of a sexual or non-sexual nature as evidence of the enterprise, conveniently avoiding the rule against the admission of propensity evidence and the limitations set out in Federal Rule Evidence 404B. So now she threw out another rule, the 404B rule, the 403 rule. Now, notwithstanding, this court was still obligated to conduct a meaningful Rule 403 analysis, which it failed to do. Rule 403 authorizes the exclusion of relevant evidence when its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issue, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The United States Supreme Court held in Old Chief that unfair prejudice as to a criminal defendant speaks to the capacity of some concedingly relevant evidence to lure the fact finder into declaring guilt on a ground different from proof specific to the offenses charged. And then it cites a case law, and then it says in that case law, it says that the committee notes to Rule 403 is explained as unfair prejudice within its context means an undue tendency to suggest decision on an improper basis, right? Wait. Oh, I went to class here. Okay, commonly through not necessarily an emotional one. All right, so the advisory committee notes of evidence 403 as Old Chief observes. What's going on? Hold on. Sorry about that, guys. I hope you don't hear that damn in the background because I just hit my desk, damn it. Sorry, I had a phone call. Let me pick up. Okay. So the committee notes to Rule 403 explains about the unfair prejudice, right? And in the committee notes on Federal Rule Evidence 403, the Old Chief observed that courts that follow the common law traditionally, almost unanimously, have come to disallow resort by the prosecution to any kind of evidence of a defendant's evil character to establish a probability of his guilt. To establish a probability of his guilt. Not that the law invests the defendant with a presumption of good character, but it simply closes the whole matter of character, disposition, and reputation on the prosecution's case in chief. The state may not show defendants prior trouble with the law, specific criminal acts, or ill name among his neighbors, even though such facts might logically be persuasive that he is by propensity a probable perpetrator of the crime. The inquiry is not rejected because character is irrelevant. On the contrary, it is said to weigh too much crime with the jury and to so over-persuade them as to prejudge one with a bad general record and deny him a fair opportunity to defend against a particular charge. So the overriding policy of excluding such evidence, despite its admitted probative value, is the practical experience that is disallowance tends to prevent confusion of issues, unfair surprise, and undue prejudice. So probative value is also informed by the availability of alternative means to present similar evidence. Specifically, the Supreme Court has advised that Rule 403, probative value of an item of evidence may be calculated by comparing evidentiary alternatives. Okay. All right. Okay, so here it says that so long as the district court has consciously balanced the proffered evidence probative value with risk for prejudice, its conclusion will be disturbed only if it is arbitrary or irrational. As set out below, the court did not consciously balance the probative value of certain proffered government evidence that carried an extraordinary risk of prejudice. In some instances, trial counsel failed to object to the introduction of such evidence, rendering counsel's performance objectively unreasonable. Oh, wait a minute. Did she say excessive? She said excessive STD evidence. The government charged the defendant with committing numerous racketeering acts in the states of California and New York by knowingly exposing Jane and Faith to herpes. This court repeatedly noted that under its interpretation oh my God. Court repeatedly noted that under its interpretation of the statutes, the government was not required to show that defendant transmitted herpes to Jane and Faith. Mere exposure was sufficient. As set forth in his Rule 29 motion, defendant quarrels with this court's interpretation of the statute, but assuming arguendo, the court is correct. There is little justification for allowing massive amounts of evidence that defendant purportedly spent decades transmitting herpes to numerous women. Well, that's what he did. I mean, from 1995 on, through defendant's physician, the government presented evidence that defendant had herpes when he was sexually active with Jane and Faith, that he knew he had herpes during the relevant time period, and that he was treating his condition with the regimen of Valtrex. Yeah, that's what he did. That's what his doc said. That's what his physician said. Both women testified that they had unprotected sex with the defendant, and that defendant did not disclose that he suffered from herpes. This evidence went unrefuted. Yeah, I think it would go unrefuted. I mean, because they had the herpes at the same time. I mean, come on now. This evidence went unrefuted. Accordingly, any additional evidence related to defendant's herpes diagnosis and transmission of herpes to other women was unnecessary. What? Did I just read that right? Hold up. Wait a minute. I'm confused. What? OMG. Wait a minute. Okay. I'm confused here. So defendant had herpes when he was sexually active with Jane and Faith, that he knew he had herpes during the relevant time period, and that he was treating his condition with a regimen of Valtrex. That's what they said. That's what his doc was saying. Listen, I was giving a man's by them blue pills was his best friends. It was his best friends. I've seen so many with these blue and hills. He was taking them Valtrex. And then both women testified that they had unprotected sex with the defendant. He didn't tell them, listen, babe, I got bumps just to let you know, okay? So in case if you get the bumps, you know where it came from, okay? But if you love me, you'll accept me, right? Okay. So this evidence was unrefuted. And accordingly, any additional evidence related to the defendant's herpes diagnosis and transmission of herpes to other women was unnecessary, cumulative, and unduly prejudicial, regardless of relevance. I'm very, wow. Did she really say all that? Notwithstanding, the prosecution admitted excessive evidence about defendant's failure to practice safe sex. Yes, he failed because from 1990 whatever to 2000 and present date, he was giving out the bumps, and that's what he was doing. And he wasn't letting anybody know he had the bumps until he decided to make Trapped in the Closet and talk about the package. He was letting us all know without us knowing. He was letting us know that he was being the whole bag, having sex with the cop's wife, the sister, the cousin, the gay guys, all these things, the guy in the closet, the guy under the sink, everybody else, the pregnant girlfriend. That was R. Kelly telling us back then he had a disease. He let us know. He gave us clues. We just weren't paying attention. We were just bopping to the beat, laughing. Like, oh, this is a funny ass story. Damn, but it's fucked up. Like everything else he did. Like the Not Guilty song. I'm not guilty. Telling people to shut up. You know, I admit. Like, really? So, specifically, the prosecution presented testimony that defendant 1 suffered from other sexually transmitted diseases prior to his sexual relationship with Jane and Faith. 2 had infected Geronda with herpes. 3 had infected Kate with herpes. And 4 had infected Anna with herpes. Oh, I forgot. Anna had herpes too. Yeah, one's for you. I ate mine already. That was yours? You gave it to her? Oh, there was 3? I thought it was 2. Papa, light up a cigarette, please. Okay, wait a minute. So I forgot Anna had herpes too. Okay, so R. Kelly gave herpes, allegedly, right, to Jane and Faith. Well, let's just say as Faith, Geronda, Kate, Anna, Jane Doe number 11 and 12. Those are other 2 girls. I think, right, those were the bad acts, 11 and 12, right? Or those were girls. No, those were different girls. Those were different girls. Bad acts, 11 and 12 were different years. Kate was, I think Kate was the 2003 one, right? Anna was 2016. So yeah, it was Kate and Anna. It was those 2. Jane Doe number whatever, 11 or 12 and 11 and 12. Or it was 11 and 12. I got to go back. We'll check that out because I'm going to do a whole live on the herpes all over again. And we're going to go through the transcripts from page 1 all the way through. Yup, it's going to be another long live, y'all. Yes, it is. So he infected 4 girls with herpes, according to the testimonies. The prosecution offered copious amounts of documentary evidence regarding defendant and his partner's herpes treatment and elicited graphic details from multiple witnesses about the symptoms of herpes. The governments uttered the word herpes hundreds of times throughout this trial. They sure did. And let me tell you, it was thousands. How about that? I think, was that? No, wait. Was it herpes that was 1,000? It was like maybe, no. In herpes, I think they used the word like 800 times or something like that. Yes, because remember, I went through the document and I typed up herpes and I highlighted every spot where they spoke about herpes. From page 1 all the way to 4,088. 4,888. So the evidence was rank propensity evidence for the reasons argued in Defendant's Rule 29 motion and above. The government simply failed to show that the so-called enterprise existed so that defendant could expose women to herpes. As such, the herpes evidence is not justified. Under the catch-all means and methods of the enterprise. It's just propensity evidence. Moreover, whatever probative value it had was significantly outweighed by its prejudicial effect. Although trial counsel voiced an objection to the admission of Kate's testimony, okay, so it was Kate's testimony, the record does not clearly indicate that trial counsel objected to the excessive amounts of herpes evidence from numerous other witnesses. This failure was objectively unreasonable since there is no possible trial strategy for failing to limit this type of other bad act evidence, which was designed to breed contempt for the defendant. Furthermore, there can be no confidence in this verdict of guilt, where it was based largely prejudicial bad act evidence, including excessive herpes evidence. Evidence concerning sexual relations with Aaliyah. The prosecution charged the defendant with one racketeering act of bribery for the sole purpose of getting evidence before the jury about his marriage and relationship with Aaliyah. Over defense counsel's objection, this court permitted the prosecution to introduce testimony from Angela, Jane Doe number 7, that she allegedly observed sexual interactions between defendant and Aaliyah in 1991 on defendant's tour bus. This court erred by allowing this highly prejudicial testimony into evidence. Angela's testimony was not relevant under the means and methods theory since it purportedly occurred pre-enterprise. This court seemed to recognize this fact, but nonetheless concluded that Angela's testimony that she witnessed sexual interactions between defendant and Aaliyah provided the motive for defendant's racketeering act of bribery. Defendant respectfully disagrees on this point. The prosecution presented testimony about defendant's alleged motive for marrying Aaliyah through Demetrius Smith, who expressly stated that defendant told him that Aaliyah was pregnant, that Aaliyah was in trouble and thought she was pregnant. Rule 703. Smith elaborated that defendant believed that he needed to marry Aaliyah to protect himself from going to jail. Graphic testimony from a third party about seeing defendant and Aaliyah engaging in sexual relations added nothing more to the motive than defendant's own admissions and the fact that he married Aaliyah. Oh, so the defendant actually put in his own admission? Wait a minute. When did R. Kelly admit that he married Aaliyah? When did he do that? He did that when Leonard said, when Leonard did that? Is that what she's talking about? Now, we're going to read this again, guys. Okay. Graphic testimony from a third party about seeing defendant and Aaliyah engaging in sexual relations added nothing more to the motive than defendant's own admissions and the fact that he married Aaliyah. Defendant's own admission to the motive and the fact that he married Aaliyah. So whatever probative value Angela's testimony had on this point was substantially outweighed by its prejudicial effect. So in other words, Bojo's like, well, R. Kelly already had admitted to marrying Aaliyah. So for him to go and, for the prosecution to bring Angela's testimony is irrelevant because he already admitted to marrying Aaliyah. So therefore, he had to engage in sex with her. He married her. Cool. What is that? He just drew dots. He didn't just draw anything.
So,
draw something.
Listen, what my plan was to make like a house in darkness and then with white stars. But then when adding the white, it messed up. So I just made like gray rocks.
Okay. All right.
And then a star in the middle.
Okay.
A yellow blob star.
Okay. I love you. So, whatever probative value Angela's testimony had on this point was substantially outweighed by its prejudicial effect. As such, it was error to allow Angela to testify about her alleged observations on the tour bus in 1991. Testimony from Addie, Alexis, Kate, Anna, Angela, Louis, and Alex. The court permitted the government to present a whopping 7 additional witnesses to testify about graphic, uncharged bad act evidence concerning dozens of sexual encounters with the defendant. Apart from Angela's testimony, which concerned sexual conduct pre-enterprise, the prosecution defended the introduction of this evidence under the catch-all means and methods of the enterprise theory. As argued above, where the defendant and the defendant alone was the enterprise, the means and methods justification for the introduction of copious amounts of bad act evidence is simply a free pass and introducing unlimited bad act evidence related to defendants' alleged sexual misdeeds and abusive conduct. This circular logic returns us to the overarching defect in this prosecution, namely that it was a prosecution of defendants' bad character and unpunished sexual misdeeds. It had nothing to do with punishing or preventing the conduct of an enterprise. Even if the evidence had some relevant purpose, the evidence was cumulative and unduly prejudicial. The jury was inundated with one jarring story after the next of unconventional graphic sex acts, including sexual conduct that many, perhaps most, would consider deviant. Example, group sex. Elements of BDSM. 2. 3 would be and coprophilia. Coprophilia? What is that? Wait a minute. What is coprophilia? What is coprophilia? Oh, we must look up this word. Yes. We gonna copy that text. Yeah, we gonna. What is this word? Coprophilia. Let's search what that is. Oh, what the hell?
Coprophilia.
Coprophilia. Coprophilia is a noun. It says interest and pleasure in feces and defecation, especially as a source of sexual arousal. Oh, hell no. Wait a minute. Hold on. We are going to, I'm going to open up this Wikipedia in this open link in new tab. Yeah, this is, wait a minute. I can't right now. Are you fucking kidding me right now? Are you fucking kidding me right now? Hold on. Hold on. You mean to tell me, guys, there is an actual word for playing with feces? It's a source of sexual arousal. But in the testimony of Azriel, Jane, aka Jane, right? She didn't say nothing about R. Kelly saying, smear this on your face and then come fuck me. He ain't say nothing of the sort. Nothing of such. According to Azriel, it was for punishment. And being that she didn't do it right, she had to do it again. It had nothing to do with him being sexually aroused. So, girl, you better go with that. Nice try. Nice try. Bojo. Nice try, Bojo. Bojo, you're trying your hardest to make anything stick. I get it. It's okay. Wow. Wait a minute. 1, 2, 3, go get more police reports. Oh, Lord. What happened aquí? ¿Qué pasó? ¿Qué? Why are you over here bothering me? Let me kiss. I love you. Love you. Have a good one, baby. See you in the morning. Okay, you guys get ready to go to sleep. Okay. Okay. Let's see here what's happening. Let's see here what's happening. Hold up. Wait. That wasn't Uncle Rob on the tape. It was the play cousin. Oh, God. Free Uncle Rob. One man ain't no. Hashtag just give it some time. Yeah. That's funny, Debo. If that's you, that's funny, Debo. Que that wasn't Uncle Rob. Nigga, you know you seen that video. It was your Uncle Rob. It was Rob with the sob. Uh-huh. One man is an enterprise. It's called individual. Individual. Okay. Okay. Let's go back to Miss Bojo. Okay. And we're going to get into that corporophilia in a minute, okay? So when considering this mass of prior bad act evidence cumulative, its probative value is diminished exponentially as compared to its prejudicial effect. There can be little doubt that defendant's jury was inclined to rectify past injustices by punishing defendant even if it harbored doubt about his guilt on the charged offenses. The risk of me and that word prejudicial I cannot. It's the whole the risk of prejudice and confusion was particularly acute where the trial devolved into a live rendition of the Surviving R. Kelly docuseries, replete with viewings of sexually explicit videos. Trial counsel objected to the introduction of testimony from Addie in a letter dated August 26th of 2021, filed under seal. But the record does not seem to reflect that defense counsel specifically objected on 401 or 403 grounds to all of the aforementioned prior bad act evidence, with the exception of Angela, but only as to her observations about defendant's conduct with Aaliyah, and not as to her own sexual experiences with defendant. Trial counsel's performance was objectively substandard, where it failed to adequately object to the introduction of this damning evidence. Trial counsel offered no written response to the prosecution's motion to allow this evidence and made no meaningful arguments at the final pretrial conference on these matters. Since trial counsel claimed that he was surprised by the proposed other bad act witnesses, he was in no position to make cogent and comprehensive arguments objecting to this unduly prejudicial evidence. So even when given another opportunity to file more fulsome objections, counsel failed to do so. So no trial strategy justifies this objectively unreasonable performance. Now, in the Merriam-Webster dictionary, the definition of BDSM is sexual activity involving such practices as the use of physical restraint, the granting and relinquishing of control, and the infliction of pain. And then it says the definition for corpophilia is marked interest in excrement, the use of feces or filth for sexual excitement. Okay, so the last words here were, performance. Inexplicably, trial counsel affirmatively introduced other prior bad act evidence. For example, trial counsel opened the door to testimony concerning defendant's prior criminal prosecution in Illinois State Court related to sexual exploitation of a child. No sound trial strategy justified telling the jury that defendant had been previously prosecuted for crimes nearly identical to those charged in the instant case. Defendant was prejudiced by his attorneys, failing where a reasonable probability exists that this court would have excluded much of the prosecution's proposed bad act evidence if it had been challenged competently. There can be no confidence in this verdict of guilt where the jury was overwhelmed with bad character evidence. Admission of graphic video depicting sex acts. Wow, wait a minute. Bonjean, are you telling me that there was videos in there? Bonjean, can you please let the people all the way in the back know that there were videos shown? Thank you. Wow. Wow. So, there was videos. Microphone check 1, 2. What is it? Admission of graphic videos depicting sex acts. Again, what do you know? Defendant was further denied a fair trial when this court permitted the introduction of graphic pornography and still photos. What do you know? And there was pictures. Okay. Defendant was further denied a fair trial when this court permitted the introduction of graphic pornography and still photos involving group sex between the defendant, Alex, and Dominique. Woo! Wait a minute! Hold up! Who said they didn't have no videos showing in the goddamn trial? Who said that? In my Portia voice. Who said that? Sorry, I'm yelling.
Sleeping right there in the living room. Right
Okay,
there.
sorry. Who said that? Wait a minute. We're gonna have to go over that again. Hold up. Wait a minute. I like the sound of what Bojo is saying. Oh shit. Bojo, you the lady right now in this very particular moment. Thank you. Oh man, oh man, oh man. Once again, I'm gonna reread it for the slow people in the back, way in the back. Make sure y'all can hear me now. Make sure you bring a piece of paper, get a pen. I need y'all to write this down and put it on your wall, your forehead, whatever, your bulletin board, whatever you got. Stick it on there, okay? Just stick it, all right? And then read it to yourself like 10 times so that it sticks in your brain. You know, because when we repeat things, eventually these things stick in our brains, right? I mean, for those who have brains, right? Okay. Otra vez que di que Nikki Six with... I can't believe she don't have a... Mommy, did you change your Nikki, did you change? Why you have... You don't have a... Okay. Because I know I didn't take you out as a moderator. So you must be on another account. Hey, Nikki, what's up, my love? Spiritual Gangster, what's up, baby? Ruby, T-Bam, what's up, ladies? Oh, that's why, Nikki. Okay, got you, babe, got you. Well, now you got 2 sticks. We make sure you're not without one, okay? Ty, what the fuck? Ty, why you don't have a stick? Bitch, I cannot with you. You're on another phone or something, right? Is that what it is? How does Ty not have a motherfucking wrench? Stop. Or Nikki. You girls, I love y'all. Okay. Hold up. Yeah. Right, Nikki, because you my number one. You've been my day one. Girl. How you not gonna have no sticks? Girl, Nikki Six gets sticks. Okay? She's the drummer, right? Right, Nikki Six is Motley Crue. I used to listen to them. Girl, I believe it's Nikki Six, right? He Motley Crue. All right, I gotta relax my hyperness. I'm gonna roll me a spliff in a minute, guys. You know, I gotta calm down a little bit because my mother told me to shut up. I'm getting too hype over here. Yes, now you can put that on your board. Yes, thank you. She's trying to track down the nephew. Mom, what's up, Mom Life? Hi, baby. All right. Okay, guys. All right. Now, I'm going to read this fucking paragraph again, okay? So, admission of graphic videos depicting sex acts. Defendant was further denied a fair trial when this court permitted the introduction of graphic pornography and still photos involving group sex between the defendant, Alex, and Dominique, who did not even testify in these proceedings, and graphic videos involving Anna. Wait a minute. Alex didn't testify? Yes, he did. Alex testified. Dominique didn't testify, but Alex testified. R. Kelly didn't testify. Then it says, and graphic videos involving Anna, including a video depicting coprophilia. They had a video of Anna playing with shit. They didn't use the video. They didn't use the video of Azriel. They used the video of Anna. So, okay. Want to spy? Okay. So our Smelly had a video, a graphic video involving Anna. Including a video depicting coprophilia, playing with feces, papito. Playing with feces. R. Kelly was like, oh shit. Trial counsel objected to the introduction of these videos. Alabet belatedly. He objected to those videos too late. Again, and for the reasons set forth in counsel's letters to this court, and for the reasons identified, supra, this evidence was not relevant to any means and methods of an enterprise, since there was no enterprise. Whatever probative value it had was substantially outweighed by its prejudicial effect. One cannot imagine a more prejudicial piece of evidence than these videos, which added very little to the testimony the jurors heard. Wow. If she brought this shit to the Supreme Court, they're going to say, girl, what are you talking about? No. Then she says, conclusion, in light of the foregoing, defendant's convictions must be vacated and a new trial ordered. Respectfully, Jennifer Bonjean, Bonjean Law Group, PLL. 2022 out of New York, New York. Okay. That's what that was, guys. That's what that was, guys. I'm going to drop the link for anyone who would like to jump on the panel and has something to say. If you don't have anything to say, then I'm gonna continue and we can talk about this corporophilia thing. Okay? Let me stop sharing screen. Okay. Okay. These people are crazy. So, corporophilia. Okay. So, okay, you see? All right, guys, do you remember, you guys, that I was telling you that there is a word for the general term for overall philiac, right? So I told you guys that the word is called paraphilia. Okay? Paraphilia is the general word for any type of philia. Okay? So paraphilia is the experience of intense sexual arousal to atypical objects, situations, fantasies, behaviors, or individuals. So behaviors like corporophilia, right? Fantasies, BDSM, individuals would be pedophilia, hebophilia, epiphilia, right? So the word corporophilia is from Greek. Okay, and corpus means excerment, and philia means the liking or fondness of. So those are the what do you call those again? Prefixes. And right, these are the prefixes. Corpora and philia. You put them together, it means excertment and liking and fondness of. Right? So they even have something called, and it's also called scatophilia. Okay, where scata in Greek means feces. Okay. And we all know that sexual arousal is what? The psychological response, right? You get sexually aroused, your body and your brain starts getting excited. We're getting prepared for sex, or we could watch porn and our heads get exposed with sexual stimuli, So it's more or less responses in your body, right? Now, Wow, this is interesting because it says that here in research, in the Diagnostic and Statistical Manual of Mental Disorders, which is DSM, which is Diagnostic Statistical Mental Disorders. Now, okay. It is classified under 302.89, known as paraphilia NOS, paraphilia NOS, which means other specified paraphilic disorder is the term used by the 5th edition of the Diagnostic Statistical Manual of Mental Disorders, DSM-5, to refer to any of the many other paraphilic disorders that are not explicitly named in the manual, along with unspecified paraphilic disorder. It replaced with DSM. So paraphilia, it says not otherwise specified. Okay. And has no diagnostic criteria other than a general statement about paraphilias that says the diagnosis is made if the behavior, sexual urges, or fantasies cause clinically significant distress or impairment in social, occupational, or other important areas of functioning. Furthermore, DSM-IVTR notes fantasies, behaviors, or objects are paraphilic only when they lead to clinically significant distress or impairment. Examples are obligatory, results in sexual dysfunction, require participation of non-consenting individuals, lead to legal complications, interfere with social relationships. Although there may be no connection between corophilia and sadomasochism, the limited data on the former comes from studies of the latter. So we know what sadomasochism is, right? Sadomasochism is the giving and receiving of pleasure from acts involving the receipt or infliction of pain or humiliation. Practitioners of sadomasochism may seek sexual pleasure from their acts, while the terms sadist and masochist refer respectively to one who enjoys giving pain and pleasure. So, Bojo, are you telling me you're admitting that R. Kelly is a paraphiliac? This is why he has his issues, because he likes to play with shit. He likes to watch girls play with shit because it turns him on. And he also likes to pick young girls because it turns him on. He can't help it but to be a pedophile, a ebophile, a hebephile. He can't help himself. He has a mental disorder. And you think that because he has this disorder, you think he might have, right? That it's okay to just do it like that and just bring the girls in like that without asking for consent from anybody, hey, baby, listen, I'm just going to let you know right now that I'm just going to pee on you, okay? Is that okay with you? He didn't do that. He didn't do that. He forced himself on them. He forced them to play with shit. It was a punishment. It wasn't nothing about sexual gratification or getting excited. It had nothing to do with that. Miss Bojo, I'm telling you, girl, it had nothing to do with that. Nothing. Then it says, a study of 164 males in Finland from 2 SM clubs found that 18.2% had engaged in corporophilia. Ooh. 164 males. That's not a lot. And that was just a study in Finland. Okay. We don't know about the United States. That was a study in Finland. And it's only 164 males. From 2 different types of S&M clubs. That 18.2% had engaged in playing with feces. 3% as a sadist, a sadist, a person who's Sadomasochism, who likes to endure pain and pleasure and give pain and pleasure, right? 6.1% as a masochist, and 9.1% as both. So in the study pool, 18% of heterosexuals and 17% of homosexuals had tried corporophilia. What do you know? Showing no statistically significant difference between heterosexuals and homosexuals. In a separate article, analyzing 12 men who engaged in bestiality, and additional analysis of an 11-man subgroup revealed that 6 had engaged in corpophilic behavior, compared with only 1 in the matched control group consisting of 12 S&M orientated males who did not engage in bestiality. And what is bestiality, guys? Right? Having sex with animals. Bestiality is having sex with animals. Only 12 men. Only 12. That's a lot. 12 men like to have sex with animals. Now, this is a little interesting thing it says here. Now, it's going to go into the society and culture of this corporophilia. Now, hold the thought real quick, because I never heard this before, but I'm hearing it now. Hold on to your seats, guys. I'm wondering if R. Kelly is imitating art. Listen to why I'm saying that, okay? American musician Chuck Berry. His name is in this Wikipedia, y'all. Chuck Berry, guys. Chuck Berry. Chuck Berry. American musician Chuck Berry recorded videos of himself urinating on and engaging in corporophilia with women. Oh, what? Oh, shit. Mm. Mm, mm, mm. Wow. Wow. So, Chuck Berry was into corporophilia, huh? He was a pedophile. He traveled across state lines and committed a man act with a 14-year-old white girl. R. Kelly, question. Are you trying to be like Chuck Berry? Are you trying to be like Chuck Berry? Did you know about these things? I'm just curious. I want to know. Did you find this interesting? You had to have watched Two Girls in One Cup. And I don't think that got you excited. I think what it did for you was more a humiliating thing. I don't know if you found that to be cute. I'm trying to understand you, R. Kelly. You're a very complicated person. Your narcissism is grandiose. You're a sociopath, psychopath, corpophiliac, paraphiliac. You, wow. Yeah. You've developed all of this over time. I definitely get that. Wow. So, Chuck Berry recorded videos of himself urinating and engaging in corporophilia with women. And it states here that in one video, a woman defecates on him after he says, "Now it's time for my breakfast." Oh, fucking shit. Okay, now it's time for me to, okay, I gotta roll a spliff, y'all. Y'all gotta give me like 2 seconds. Hold up. Man. Is this real? Guys, can y'all help me Can y'all help me out? He said, "Now it's time for breakfast, baby. Lay it on me." Did he really say that? Chuck Berry, what the? Oh, Jesus Christ. Guys, this is outrage. I'm going to share my screen with y'all. Y'all think I'm fucking lying. For the ones in the bushes, I'm not lying. Check this shit out, y'all. This is not a joke. This is not a joke. I'm going to let the read aloud read for a second while I roll my spliff. Yeah, let's see how this goes.
Coprophilia From Wikipedia, the free encyclopedia. This article is about the paraphilia. For dung-feeding fungi, see coprophilous fungi. For the form of Tourette syndrome, see coprolalia. Smother box for engaging in erotic coprophagy. Coprophilia, from Greek kappa pyro-omicron, copros excrement and phi iota lambda alpha, philia liking, fondness, also called scatophilia or scat, Greek. Sigma kappa alpha tau, scata feces, 1, is the paraphilia involving sexual arousal and pleasure from feces. 2, 3. Contents. 1. Research. 2. Society and culture. 3. See also. 4. References. 5. Further reading. 6. External links. Research. In the Diagnostic and Statistical Manual of Mental Disorders, DSM, published by the American Psychiatric Association, it is classified under 302.89 paraphilia nos, not otherwise specified, and has no diagnostic criteria other than a general statement about paraphilias that says the diagnosis is made if the behavior, sexual urges, or fantasies cause clinically significant distress or impairment in social, occupational, or other important areas of functioning. Furthermore, the DSM-4 notes, fantasies, behaviors, or objects are paraphilic only when they lead to clinically significant distress or impairment, e.g., are obligatory, result in sexual dysfunction, require participation of non-consenting individuals, lead to legal complications, interfere with social relationships. Although there may be no connection between coprophilia and sadomasochism, SM, the limited data on the former comes from studies of the latter. A study of 164 males in Finland from 2 SM clubs found that 18.2% had engaged in coprophilia, 3% as a sadist, 6.1% as a masochist, and 9.1% as both. 4. In the study pool, 18% of heterosexuals and 17% of homosexuals had tried coprophilia, showing no statistically significant difference between heterosexuals and homosexuals. In a separate article analyzing 12 men who engaged in bestiality, an additional analysis of an 11-man subgroup revealed that 6 had engaged in coprophilic behavior, compared with only 1 in the matched control group consisting of 12 SM-oriented males who did not engage in bestiality. 5. Society and culture. Russian coprophiliac erotica depicting defecation on a sleeping victim. 1 definition of the term hot Carl. American musician Chuck Berry recorded videos of himself urinating on and engaging in coprophilia with women. In one video, a woman defecates on him after he says, "Now it's time for my breakfast." 6. 7. He was also sued for videotaping dozens of women in the restroom of a restaurant he owned, which has been identified as being motivated by his coprophilia fetish. 8. 9. The Cleveland steamer is a colloquial term for a form of coprophilia, where someone defecates on their partner's chest. The term received news attention through its use in a U.S. Congress staff hoax email, and being addressed by the United States Federal Communications Commission. 10. Hot Carl, also hot sasser, is sexual slang referring to one of several purported acts involving feces. It variously means an act of defecating on one's sexual partner, defecating on someone who is asleep, or defecating on someone's face while covered in plastic wrap. 11. According to psychologist Anil Ugrawal, it is a synonym for a Cleveland steamer and is part of a coprophilia vocabulary that also includes the dirty Sanchez. 12. The term was adopted as a name by rapper Hot Carl. 13. Dirty Sanchez is a purported sex act which consists of feces purposely being smeared onto a partner's upper lip. Sex advice columnist Dan Savage dismissed the act as completely fictional.
Wait! Pause! What? They have different types of terms for what you're going to do to your partner. Wait a minute. We got the Cleveland steamer. We got the hot Carl, also known as the hot sasser, and the dirty Sanchez. So which one did R. Kelly make Azriel and Haley do? The dirty Sanchez. I wonder if he made them do the hot Carl. or the Cleveland Steamer? Oh. What? Wait a minute. Right. What is going on, SK? What the hell? Oh, shit. This is disgusting. R. Kelly wants to be a Chuck Berry. Chuck Berry's music should be banned too. Stop playing his music too, God damn it. What? Let's continue. Oh my God.
Fictional, 14, unreliable source? Brian Baldry in Dirty Words, a literary encyclopedia of sex, says the act is an urban legend. 15. The New Partridge Dictionary of Slang and Unconventional English says, this appears to have been contrived with the intention to provoke shock rather than actually as a practice, although, no doubt, some have or will experiment. 16. If so, this makes it an actual practice. Columnist Gustavo Arellano of Ask a Mexican contends the term evokes the stereotypical mustache of a Mexican. 17. Dubious, discuss. The term for the sex act entered British gay camp Polari in the 1960s. 18. See also. 2 girls, 1 cup. Analingus. Asked to.
Hold up. Let's go to the 2 girls, 1 cup real quick. Okay. 2 girls, 1 cup. Hey, honey. Hey, Jacqueline. What's up, mama? What's up, Aisha? 2 girls, 1 cup. It is the unofficial nickname of the trailer for Hungry Bitches, which was a 2007 Brazilian scat fetish pornographic film produced by MFX Media. So this came out in Brazil. And the trailer features 2 women defecating into a cup, taking turns in what appears to be consuming the excerpment and vomiting into each other's mouths. Now it says Lover's Theme by Hervey Roy plays throughout the video. That's the song, Lover's Theme. It was a song by Hervey Roy. And it says the video became one of the best known shock videos in itself. And for the reactions its graphic content elicited from viewers who had not seen it before. Around mid-October of 2007, video sharing sites including YouTube, were flooded with videos of the reactions of first-time viewers. Let's see if I can open this in another link. Let's see what happens when I go here. Oh, okay. They took it down. All right. Let me see. This was a cute with Chris versus 2 girls, 1 cup. This one was the internet can't replace TV. Let's see. Oh, this was 5. Oh, okay. So let me see. Let me see if they had 3. Okay. Let me see. Okay. Oh no, this is just a screenshot. It's not the actual reaction video. Okay, I was trying to find. Let me see the other one. Go back. Okay. Let me see. Wait. This one right here. Oh no, go back. Right here is. Okay, that was the one I just saw. Okay. Oh, okay, so it's gonna get to that anyway. Alright. So the title of the song is, the video was Hungry Bitches. It said that in production, it says viewers often speculate that the apparent feces are actually food substances such as refried beans, ice cream, or peanut butter. So the actual people that were watching these movies, the viewers, they were speculating that the feces are food substances like refried beans or ice cream or peanut butter. And some speculate that the vomit is real, but was regurgitated before reaching the stomach and does not contain any gastric acids. In the video, the majority of the vomit does not enter the mouths. Pornographer Marco Antonio Fiorito unsuccessfully argued in a criminal court proceeding that the experiment was actually chocolate ice cream. So I guess he had to go to court. It said pornography and the criminal pornography and the criminal justice system. Okay, so this guy who actually the distributor from a Brazilian distributor and pornographer, this guy Marco, he describes himself as a compulsive fetishist, which is sexual fetishism or erotic fetishism. Erotic fetishes and sexual fetishes is a sexual fixation on a non-living object or non-genital body part. So the object of interest is called the fetish. So the person who has a fetish for that object is a fetishist. A sexual fetish may be regarded as a non-pathological aid to sexual excitement. Interesting. So there's quite a few of these types of, they have this thing called analingus, which is the oral and anal sex act in which a person stimulates the anus of another by using the mouth, including lips, tongue, or teeth. It is also called anal oral contact and anal oral sex, and is additionally known by slang names. So, yes, people get down. I myself have been there. I've experienced that. I've done it. Wash your ass. We okay. Long as you wash your ass, we okay. Okay. It's a sexual fetish, right? Right? Okay. It's normal. Not everybody's into it. Not everybody does it, but it's normal. Right? Now they have ass to mouth, which is removing the penis from the passive partner's anus, followed by its immediate insertion into the mouth. Now, that's not happening. That's not happening. This is not happening in my world. Ass to mouth, not happening. No. No. Just wash your ass and I can lick your ass. That's all I'm worried about. I don't know about all this dip it in me and then dip it in my mouth. This is not happening. Where's this happening at? Not in my world. In the R. Kelly world. Hey, information man, what's up, puppy? Try saying that about 5 times fast. Right, information man? Sally sells she shells by the seashore. Oh, wait a minute. Yo, Nikki. Yo, it's funny you say that, girl. I heard Hollywood, right? And she was like, Peter Piper picked a peck. I was like, wait a minute. What's she talking about? She didn't even say it right. She did not. It's Peter Piper picked a peck of pickled peppers. No. Peter Piper picked a peck of pickled peppers. How many pickled peppers did Peter Piper pick? Now try saying that shit fast. Girl, you can't do it. Stop lying. If a woman's clean, high five, information man. High five, okay? If you're clean, I mean, why would they fart? I mean, you think they would have a queef? Are we having queefs to our butts? I don't know. This could happen. I'm learning new stuff right now. We're learning together. Let's learn together. You know, Diva. Yes, we like to learn over here. So, now we're talking about corporophagia, which is known as the actual consumption of feces. Who's doing this? I'm not doing this. Why are we doing this? I'll lick your booty as long as it's clean. I don't know about eating your shits. No. This is not happening. No. All right, Kelly. Information man. Yo, information man. Why is Bonjean putting in a motion for a new trial stating that R. Kelly has this, what is it called again? Corporophilia. That he likes corporophilia. And corporophilia, we learned, is also called scatophilia or scat. And it is involving the sexual arousal and pleasure from feces. Why is she doing that, information man? Please. Pow, pow, mommy. That's right. Ritz crackers was bomb right up into peanut butter. They was good until you heard peanut butter. I say no to that too. Crazy, right? What is she doing? What is she doing? Like, oh man. And guess what, Information Man? We just found out today that Chuck Berry recorded videos of himself urinating on girls and engaging in eating feces and playing with feces with women. Well, not eating it, corpophilia, which is playing with it. Playing with it. And in one video, he actually had a woman defecate on him after he said to her, "Now it's time for my breakfast." What? And he was sued for videotaping dozens of women in the restroom of a restaurant he owned. And that restaurant was identified as being motivated by his corpophilia fetish. Right, like, why are we playing with poop? What is so cool about poop? I mean, ugh. This is, who's your Lord? Wow. So, Chuck Berry, huh? Interesting. And then we had, right now, paraphilias are sexual interest in objects, remember, situations, or individuals that are atypical. Remember, paraphilia is the overall general word for sexual interest in objects, bestiality, right? Corpophilia, situations, polyamorous, right? BDSM, and then individuals, hebephilia, epiphilia, pedophilia. These are all type of paraphilias. Okay? And as we know, sadomasochism is what? Inflicting or receiving pain or humiliation. Right? Okay. Urolangnia. Urolangnia associates sexual excitement with the sight or thought of urine or urination, and may also refer to such behaviors or acts. It is a paraphilia. So, like I said, R. Kelly for me is a paraphilia. Punto. Generalization. We're not going to call him pedophile. He is a paraphiliac. Paraphiliac. He's sick. And he needs fucking help. And he needs to be in jail. All at the same goddamn time. At the end of the day, he still needs help. I don't know how much the help is going to work because he's going to wind up being in jail for a long time. And if he's not in jail for a long time, he better get the fucking help he needs. ASAP. Because he can't be out here on these streets continuing these behaviors. He is a danger to the community. That's why he never got bond. Sarah. Right, Aisha? Chuck Berry. Like, what? I think he was imitating R. Kelly. I can't even make up excuses for this guy. Seriously. So, let me see. Oh, can you guys see this? I don't know if I'm sharing this. Oh, no, wait. Share this tab instead. Okay. All right. Do you see that, guys? Oh, that's as big as it went. Let me see. I'm gonna download it. Let me see if you guys. Okay. That's the video. Wait, let me see. Can I? Oh no! Wait. Ugh. Sorry, y'all. I'm not supposed to. Isn't it supposed to get bigger? Okay. So this was the video. HB Hungry Bitches, Too Extreme to Print. XXX. Okay. I don't know. Let me see. Have we gotten anything yet? They should have. Oh, yes, we did. Let's go check it out, guys. Let's go check it out. Let's go check it out, y'all. Thank you for reminding me, Sarah. I lost track getting all into this feces. Lord of mercy. Okay, guys, let's see. Here we go. Let's see. Let me refresh this. Oh, I forgot. Right. Okay, I got you, brother. I got you. I won't forget. Okay. Okay, here we go. Response in opposition. Okay. Download. Okay, let me go back. One. Oh, wait. Oh, wait. Oh, you download will be in a separate video. Okay, wait. Which one did I just do right now? Let me go to Pesa. Oh, shit! Guys! Is this... What? Breon Peace, United States. Oh, they got a new attorney on board here. Or... No, it's the same. This must be another attorney for the government. Oh, shit, you guys. Oh, shit. Well. They even answered to her motion that she just put in. Hold up. Wait a minute, guys. Wait a minute. Wait, is this the same amount of pages? Hold up. Oh, yeah, this is the same thing. Okay, espérate. I got it twice here now. Damn it. Okay, let me go back one. All right, wait a minute. It says 14 pages. No, that's the one from before. Oh, wait, go back. Ugh. Let me go back here. $278. That was $276. So it's got to be $277. Here we go. Right, because it was okay. So $277. Download. And this one's 45 pages. Holy shit! This one is the government's response to Rule 33. And then we got, holy cow, this is a lot of pages, guys. Oh my goodness. We're going to have to, shit. Tables, okay. This is what? This one is the government's memorandum of law. This is for the acquittal. And the other one is for the new trial. All right. So you know what we're going to do? Being that this one is 49 pages, we're going to go through this one first. And then we could do the other one tomorrow. How's that? That sound good? Because the other one's 109 pages. Like, wow. That's, I mean, okay, so page 1 starts here. Let me see if it's got, like, anything, like, if it's a little short, you know what I mean? Because let's see what this could do. Wow, the government is breaking it all down. They broke it all down into 109 pages. Oh, wow. Wow. Oh, soy chacho. Mira. Mira. Oh, wow. Okay, so this one is for what again? Weesh. All right, so this one's for the acquittal. So this is the one that's the most important right now because this is the first motion that Bonjean had put in. Oh, God, guys. What time is it? Holy shit. Holy shit. Okay, guys. I don't know if you guys want to stick on. You guys want to stick around or should we do it tomorrow? The response is in there, but mommy, for Miss Bonjo, I think so. Right, I'm going to rename this one and do them as separate lives. Okay. Yeah, I should, because it's really long, guys. One is 45 fucking pages. The other one's 109. Like, we'll be here on a marathon. I'm not trying to do that. It's already 12:30. Right? I'm going to come on early tomorrow. Oh, shit. I got to go. I have an appointment early in the morning. When I come back, I always get to distractions, guys. Pray for me, guys. Pray for me that I don't get no distractions and I can come to you guys early. Yeah, I should definitely separate these lives. Yeah, this is a lot. Okay. Yeah, let me download this. Now the other one is right. This one's the no. This one's for new trial. I gotta rename that. This one is the acquittal. All right, now let's see. This one is okay. What was this again? I forgot what this was here. All right, this is an that was just an example. Okay. All right. Yeah, I'm gonna definitely separate these lives. We're gonna come back tomorrow. Why would he be reading the government's response right now, knowing that I'm live? Really? Amos! I'm gonna beat you up. I'm gonna beat you up, Atmos. ¿A qué hora? That's what I was saying. I was wondering if I could do the 45-page one now and then do the other one tomorrow. But if I do the 45-page one, I think I would let the reader read it because she'll go faster. You know what I mean? Yeah, more or less a little bit after lunchtime, mommy, because where I'm going is a doctor's appointment. So And these people in this place are slow as hell, girl. Slow as hell. And I got to be there at 9 a.m. And when I usually go, I'm usually out by at least 12:30. Right? I'm usually there like 4 or 5 hours. Right. 10, 11, 12, 1. By 1 o'clock, maybe. More or less. After lunch. Yeah. 1, 2 p.m. More or less, I think. You're right, Noonie. I might just be back by that time. I just might be back by that time. Yeah. All right, Sarah. Good night, my love. Yes, that's right. It's like 5 o'clock in the morning for you. Are you getting up or are you going to sleep? Okay. So what should I do, guys? All right, cool, babe. So you can help me out. Awesome. Thank you, Jacqueline. Right, it's a separate lives, right? Yeah. So I'm going to end this one. I'm going to end this live, guys, and I'm going to reschedule for tomorrow, okay? In the meantime, go watch Atmos, find out what's going on over there. And, yeah. And then you can help me. Definitely, baby. Thank you, Jackie, for giving me the 411, my love. Gracias, mi amor. Right, that's what I'm saying, YM. Hi, baby. Welcome, welcome. Yeah, I think I'm going to do it tomorrow, right, guys? So I should shut this down and you guys go over to Atmos's. All right? And then tomorrow you guys will get my point of view and, you know, my reaction off of it. Because it's a lot. That's a lot. I don't know if Atmos is going to be up to the crack of dawn and shit. I mean... So I'll schedule it for tomorrow. I'm going to change the title in this video. And I'm praying that our girl, Miss Esquire, Empowered Esquire TV, I'm praying that she's not busy for me Wednesday and maybe she can help me out with breaking down the whole Michigan thing on Wednesday. I know she's very busy, you know. So I hit her up again, so hopefully she can respond. And I can do the Minnesota thing with her. And then, you know, maybe she could even give us her opinion on what's going on now with the whole motions that the government has responded to and Bonjean's 33 and 29 motions. So good night, my loves. I love y'all. Thank you, guys. Yeah, so please do me a favor, guys, before you jump out. Don't forget, por favor, hit that like button, okay? Please subscribe if you're not subscribed to my channel. Thank you. Like the video. Hit the notification bell on the side. Make sure you put it on all, guys. And if you are watching the replay or you didn't want to jump in the chat, you can leave a comment below in the comment section of the video, guys. And if you are not a member of my members only crew, Badass Divas, please join the membership. I give exclusive content when the exclusiveness comes, and it's just private for everyone. We go over there. We go to the private section, okay, for members only. It's $1.99 a month. It's not a lot. That's the only tier I have. You get perks as putting little emojis into the chat. Okay, you can put the emojis in the comments section of the video when you're engaging. And you also get exclusive content. I read books over there and stuff like that. Like, we're going to get deeper into that later on, but I kind of want my audience to grow over there, you know, because views, everything has to do with views, right? I am a content creator and I need for views to be up in order for my monetization to work out, for me to get over the threshold of $100 a month. You know, so right now I'm getting paid every 2 months. It's not even monthly. But your membership does help keep this channel alive. It pays for all the bills that deal with the StreamYard, the internet, any equipment that might go down. Like right as of recently, I got new microphones, I got a new keyboard, a new mouse, you know, these things, a new camera. You know, these things, they break down, they're cheap, you know, but it is what it is, and that's what keeps this channel going, y'all. So please don't forget to support your girl always. You can either hit the Cash App, you can hit my PayPal, you can hit my Zelle, or you can always hit the super chat in the box below when you are chatting. Okay, guys, I love yous. Thank you once again. Peace.